Nnamdi Kanu a flight risk, the federal government tells Supreme Court. The statement said, "This is the time to show magnanimity and statesmanship. The appeal court has provided the leeway for the authorities to walk the talk as one desirous of preserving Nigerians' unity and respect for her diversity. The federal government has filed 7 grounds of appeal against the October 13th Court of Appeal judgment, which discharged the leader of the indigenous people of Biafra, Nnamdi Kanu. It asks the Supreme Court to set aside the judgment and restore the charge against the respondent to be tried at the trial court." The government, in a motion on notice in support of the appeal, is also seeking a stay of execution of the judgment of the court presided over by Justice Juma Sarki, pending the hearing and the final determination of its appeal, noting that the IPOB leader posed a flight risk. The notice of appeal dated October 18 was signed by the Director, Public Prosecution of the Federation, Mohammed Abubakar, the Assistant Chief State Counsel, D. Kasue, and A. Alako, and Senior State Counsel, G. Wanze, the Department of Public Prosecution, Federal Ministry of Justice. The appellants availed that the appellate courts held in law when it held that the trial court had no jurisdiction to try Kanu because of the extraordinary rendition of the respondent. It stated there was no evidence led by the respondent before the court of the first instance, and indeed before the court below, to show how he was allegedly adopted and renditioned to Nigeria as required by Section 139 of the Evidence Act 2011, since he alleged that he was adopted without following due process of law. The appellant also contended that the court below held when it held that the executive arm must not be allowed to benefit from the abduction of the respondent, when in fact and by its judgment, the respondent was allowed to benefit from his illegality of disobeying the orders of the court when he jumped bail, and was rewarded with a discharge from the charges pending against him at the trial court, thereby occasioning a miscarriage of justice against the state and the victims of the crimes perpetrated by the respondents. The government claimed that the appeal court was wrong by saying that how Nnamdi Kanu was brought back to the country can vitiate and indeed weaken the criminal charges of treason and treasonable felony and terrorism brought against him. It added that the lower court made that decision without taking into account the fact that the nature of the entry of the respondent is not relevant in the determination of the charges against him. The appellant further stated that the appeal court justice failed to be bound by established judiciary precedent on the mode of entry of a defendant charged with the commission of an offensive established by the Supreme Court. The appeal court, the federal government noted, misdirected itself when it relied heavily on the Organization of African Union's Convention on the Prevention and the Combating of Terrorism, the African Commission on Human and People's Rights, and cases decided from foreign jurisdictions as against the substantive law covering the criminal procedure in Nigeria. The court below overlooked the submissions of the appellants with regard to the ACJA 2015, which takes its taproot from the ground non Section 36 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to the effect that is the Administration of Criminal Justice Act 2015 that governs the trial of every Nigerian charged with the commission of crime. The failure occasioned the miscarriage of justice, the appeal notice read. The federal government further argued that the court below held in law when it discharged the respondent of the offences mentioned in count 1, 2, 3, 4, 5, 8, and 15, bordering on terrorism offences contained in the amendment charge dated January 12, 2022, and retained by the trial court for words of jurisdiction. The appeal observed that the appellate court was completely silent and closed to its eyes to the obvious facts of the issues which predate the rendition of the respondent because he was standing trial for conspiracy and treasonable felony terrorism before his escape. If the learned justice of the Court of Appeal had taken into a consideration the act of legality of the respondent in jumping bail and the conspiring duty of the appellant to ensure his presence in court, the decision of the court would have been different, the appeal read. In affidavit, Lome Udobo of the Department of Public Prosecution, Federal Ministry of Justice, stated that Kanu has a history of jumping bail and may be difficult to secure if the appeal was not granted. The affidavit read. In an affidavit, Loma Odo of the Department of Public Prosecution, Federal Ministry of Justice, stated that Kanu has a history of jumping bail and may be difficult to secure if the appeal was not granted. The affidavit read that the respondent is a flight risk person given his previous antecedent of jumping bail while standing trial. The respondent is a dual citizen of both Nigeria and Britain, which will make it easy for him to move out of Nigeria and escape justice. That the respondent's presence will be difficult to secure should the judgment of the court below is not overturned and set aside by the Supreme Court. There is a need to stay the execution of the judgment of this honorable court to avoid a situation where the judgment of the Supreme Court will be overreached and rendered nugatory. Meanwhile, the Southeast Caucus in the Senate has intervened in the case of the federal government against Kanu, urging that the ruling by the Court of Appeal be obeyed. So guys, I'm dropping it here. Kindly share your thoughts below the comment section.